There had to be some way to make this lawsuit go away. It didn't make any sense. My business was incorporated in Delaware. I had lived in California for more than a decade. I didn't have anything in Maryland. No office, no employees, no assets, no servers, nothing. The last time I had been in Maryland was 2010 for a payments conference in Baltimore. For a lawsuit to stick, there has to be jurisdiction. But even to make the argument that the court has no jurisdiction, you, or if you're a company, your lawyers, still have to show up in court. I wanted to avoid the showing up in court step if there was any possible way. What was the point if there was no need? I decided to try calling Joe Johnson to see if there was any chance he might be reasonable. Sometimes, just hearing a human voice is enough to get over a conflict that has taken place exclusively on paper or by email. I called twice at 2 different numbers that Johnson had provided on the Contact Us form, but he never picked up. Now that Paul and Oliver were representing Think, all we could do was proceed with the notice of removal. Paul thought it was best to let the notice of removal I had mailed on my own, before he got involved, arrive in federal court without doing anything to try to prevent it from being processed. He reasoned that he and Oliver could always file an amended one with a lawyer's signature on it if it was really necessary. I tracked the package online on its way to Baltimore, and then, once it was delivered, I started checking Pacer nonstop, hoping that the case being docketed in the federal court would mean the beginning of the end of this Maryland nightmare. I was looking to see if the latest case number that had been entered in the District of Maryland was my case. Eventually, I realized that I was looking in the wrong place. The district used multiple location codes, which are the first digit of a federal case number. 1 meant Baltimore, but 8 meant Greenbelt, the federal courthouse that handled cases in Prince George's County. Eventually, the clerks got to my envelope in their intake pile. Case number 8:22-CV-02422-TDC was entered into Pacer's database, and the case was randomly assigned to Judge Theodore D. Chuang, the TDC at the end of the case number, one of 6 federal district judges based in Greenbelt. The caption was entered as Johnson versus Think Computer Corporation. Judge Chuang had the kind of pedigree you might expect from a federal judge. He went to Harvard undergrad and Harvard Law School after that. Barack Obama appointed him in 2014. Now, I guess I should say I went to Harvard and I have some issues with the place. But generally, I think it's true that people with Harvard degrees tend to be smart. Not always entirely ethical, but generally pretty smart. So I was somewhat hopeful that when Judge Chuang finally got around to examining this case, he'd see what was going on and I could move on with my life. Yeah, that is not what happened. From Think Press and PlainSite, this is Broken, a podcast about what we like to call the rule of law and how in the United States there isn't one. We'll talk about all aspects of the legal system through the lens of PlainSite, a legal and financial research platform where you can find information about things like lawsuits, lawyers, companies, and judges. On PlainSite, anyone can read anything the government produces for free with no account. It really does put the world's complexity in plain sight. Now that the Johnson case was in federal court in the District of Maryland, it too appeared on PlainSite. There was some irony in this fact since Johnson's initial goal was supposedly to get his case removed, not to add another. But once it was there, I couldn't even track it easily because Maryland's federal courts aren't much better than its state courts when it comes to transparency. The Pacer RSS feed, which syndicates updates from the courts across the internet, is disabled for Maryland, as it is sporadically for various Pacer districts across the country. Every step of the way, I would have to fight tooth and nail just to figure out what was even going on, and the fight was only just beginning.
I said, Mom. She said, yes. I said, didn't Dad go past the turn? She said, yes. I said, well, why don't you say something to Dad? My mother said, your father knows what he's doing. My wife would have done a half hour on me. Would you please pull over so I can get a bus or a cab or something? I'd like to ride with somebody who knows where they're going. You know, this area has already been discovered. Wonderful. The arguments that I have with my wife.
If that voice seems familiar, you probably already know it's comedian Bill Cosby, back in his heyday. The super condensed version of the story is that Cosby went from being known as America's dad, a wholesome, incredibly successful, and famous comedian who refused to swear in his comedy acts and routinely moralized against others, to the guy who was serially drugging and raping women the whole time he was telling the world, and especially African Americans, how to behave. Cosby was convicted of sexual assault, but his conviction was overturned by Pennsylvania's Supreme Court in 2021, and he was freed from prison. Cosby's career arc, from achieving near universal respect and incredible wealth as a minority in America, to the absolute depths of shame and revulsion, not to mention prison, was singular in the magnitude of its stunning reversal. As I was reading through case after case after case about Joe Johnson, I was not expecting to find Cosby's name, but there it was. Apparently, Cosby was something of an inspiration to Johnson, as he was years ago to many people. Both were African American. Johnson was at the time in his early 50s, as Cosby had been at his peak, and they had something else in common. In 2021, they were both freed from prison on technicalities. It's actually kind of difficult to pin down exactly how many times Joe Johnson has been sent to prison. I think it's 4. But regardless of the exact number of times he was incarcerated or the number of prisons he traveled through, it's fair to say that Joe Johnson had been to prison a lot by the time he was released by conservative judges on the United States Court of Appeals for the Third Circuit. Now, I have to say, this is the horrific fate of many black men in the United States, in and out of prison, often for fabricated or highly exaggerated trespasses. According to Pew Research, and this is a quote from their issue brief entitled, "Racial Disparities Persist in Many U.S. Jails," quote, "By the year 2000, black people made up almost half of the state prison population, but only about 13% of the U.S. population. That's crazy. And in a sense, they didn't just get there by mistake, although you could argue many of them did. Lawyers put them there. Both the legal profession, by prioritizing its own economic interests over representation of people who they claim need their services, and the lawyers in robes we call judges. But Joe Johnson's story is a little different, because this is not a story of police brutality, overzealous prosecution, or racially motivated sentencing. Johnson actually committed the crimes he was sentenced for, and while a white criminal who committed the same crimes might have gotten a lighter sentence, I think maybe not. The nature of his crimes kind of sets him apart. Based on publicly available documents, Johnson's tangle with the law started in 1993. To explain what unfolded, I'm going to read passages from some court opinions that cover a bit of the history. The first opinion is from Johnson v. Xerox Educational Solutions, LLC, and it was written in 2016. As you'll hear, that opinion quotes another one from 2008, which is Johnson v. U.S. Department of Education. I'm going to skip over citations and some portions as I read these, because otherwise it just becomes impossible to understand. But if you want to read the full opinions, there are links to the documents on PlainSite in the description for this episode on YouTube. Here we go. Quote, "The United States District Court for the District of Columbia has summarized the background of Johnson's claims. Johnson was indicted for larceny and burglary on February 16, 1993, and given a suspended sentence on April 21, 1993. That same year, he enrolled at the University of Maryland University College, or UMUC. He obtained federally guaranteed loans, including federal family education loans, for the fall 1993, spring 1994, fall 1994, spring 1995, and spring 1996 semesters. The loan application form did not ask about Johnson's criminal history, and he did not tell. While enrolled, Johnson took several courses offered by UMUC's Paralegal Studies program. On April 29, 1996, Johnson withdrew from UMUC because he was incarcerated, this time for forgery. In 2004, after his release from prison, Johnson consolidated his loans under the William D. Ford Federal Direct Loan Program, administered by the United States Department of Education. In efforts to avoid repaying his student loans, Johnson has sued everyone involved under every conceivable theory. This suit is just the most recent installment. So that was a court in 2016, quoting a court in 2008 about what happened in 1993. Thus far, we know that Johnson got involved in some theft in early 1993, enrolled at the University of Maryland to study as a paralegal, wasn't exactly truthful about his recent past, took out some loans to pay for his studies, and then withdrew 3 years later when he went to prison. Then, after he got out of prison, using his aborted paralegal training, he started suing over those loans. One of those cases then showed up on Google because it had been automatically indexed on PlainSite, and after 6 years of threats, Johnson sued Think to try to make it go away. A court opinion from another case in Virginia, actually entitled Johnson versus Commonwealth of Virginia, gives a bit more color to these events. When the court uses the word appellant here, it's talking about Johnson because he's the one who filed the appeal being ruled on. The term nolle prosequi, abbreviated nol pros, means to nullify a prosecution, meaning that if you've committed a crime, it's the equivalent of the government shrugging, saying whatever, and giving up. I'll warn you, this passage is an example of something that's extremely common in law, which is terrible legal writing, both the judges and Johnson's. You'll notice Johnson has a penchant for the kind of flowery, stilted language you often see in law, but he struggles with basic grammar and spelling, which perhaps reflects that he never had much of a chance to obtain a good basic education. The opinion bounces all over the place and is a bit lengthy, so if you're thinking of grabbing a cup of coffee or something, this might be a good time. I've done my best to condense it without changing the meaning. Quote, on March 23, 1993, appellant appeared before Arlington County Circuit Court Judge Paul F. Sheridan on case number 93-321, charging appellant with statutory burglary, a felony. Appellant agreed to plead guilty to the lesser included offense of misdemeanor unlawful entry. In exchange for his Alford plea, the Commonwealth moved to nol pros case number 93-322 involving grand larceny. Without objection, Judge Sheridan nolle prosequied case number 93-322. On May 3, 1995, appellant filed a motion for expungement in which he alleged the following: that your petitioner, Joseph Johnson, was arrested on the 11th day of January 1993 by the County of Arlington Sheriff's Department for statutory burglary and grand larceny. 2. That your petitioner, Joseph Johnson, was innocent of any and all charges aforesaid. 3. That on the 23rd day of March 1993, the County of Arlington moved for a nolle prosequi of said charges, which motion was granted by the court. There are no transcripts or orders regarding the expungement proceeding. The only information about that proceeding is contained in the April 29, 1996 transcript from appellant's forgery trial. At that trial, Sheila Norman, the assistant Commonwealth attorney who handles expungements usually, testified that on June 16, 1995, she learned that appellant's expungement proceeding was on the docket to be heard that day. That was the first time Norman was advised of the petition. After hearing conflicting arguments, the trial judge denied appellant's petition for expungement. On June 16, 1995, the same date as appellant's expungement hearing, the Commonwealth asserted that appellant still owes $1,500 in restitution. Appellant averred that his probation was transferred from Virginia to Maryland, where he had been making minimum payments of $50 to the probation officer there. The trial judge indicated that the Virginia Probation Office requested that appellant's probation be extended. He then ruled that he was extending the probation to March 23, 1996 for lack of compliance. On August 21, 1995, appellant was indicted for forging and uttering the order in case number 93-321, the order upon which appellant relied to expunge his record and the case in which Judge Sheridan extended probation. The Commonwealth alleged that appellant visited the Circuit Court Clerk's office on June 7, 1995, and stole the original orders from the file and the order book for case number 93-321, relating to his 1993 misdemeanor conviction. According to the Commonwealth, appellant prepared a forged order indicating that the charges were nolle prosequied. The Commonwealth alleged that appellant then substituted a photocopied forgery for the original conviction order when he returned the file to the clerk. At appellant's trial, because the Circuit Court had no original orders from which to make certified copies, the Commonwealth sought to admit a copy of the conviction order provided by appellant's probation officer. At appellant's April 29, 1996 trial, appellant's attorney questioned how the Commonwealth intended to prove the contents of the original order that was allegedly stolen and replaced with a forgery. The Commonwealth explained that it intended to present a copy of the original order received from the file of appellant's probation officer, Carol Hawkins, and to establish its authenticity through the testimony of Hawkins and two Circuit Court assistants, Vicky Saparis and Beth Davis. The Commonwealth's attorney further asserted that she was not trying to prove the contents of the order. Instead, she merely intended to prove that appellant was convicted in case number 93-321, and that the case was not nolle prosequied as indicated in the alleged forgery. Defense counsel objected. The prosecutor explained that the order could not be authenticated and certified because the original has been destroyed and they can't certify a copy. The prosecutor then informed the trial court of other documents she intended to introduce for admission. She stated, "The best way we should probably settle this issue of the exception is I have a document that I will put in as Commonwealth's Exhibit Number 2, will be a photocopy of his actual no pros order. That is not certified. The original is missing out of the file, I believe, and so I would be introducing it not just based on its certification, but because it is something that has been recognized by the clerk. The clerk knows what it is. Then, the third thing I'm going to be submitting is the fake order, the constructed order. And of course, that can never be certified, it's false. It's just a piece of paper that was put in the file. The following exchange ensued. The prosecutor: Your Honor, if you think 8.01, the section referred to as preventing introducing the no pros order, if it is not certified, now that they have gotten the book and page from the Supreme Court, they can use that as an original I learned during the break from Ms. Saparis. The court: I think you should do that. Saparis, a court assistant in the Circuit Court Clerk's office, testified that she saw appellant on June 7, 1995, when he came into the clerk's office asking for copies of a file, and she went to go look for the file for him. Saparis gave the files to appellant, who had them for probably 15 to 20 minutes. Because of other activity in the office, Saparis did not watch appellant closely. According to Saparis, appellant asked for certified copies of the orders in the two cases. However, she noticed that they were Xeroxed. Saparis testified as follows: I told him that I needed to find the original in order to give him a certified copy, because all this was a copy, and our office policy is not to give a certified copy of a copy. Saparis also noticed that most of the contents of the file were copies, and that the returned file was pretty thin. Appellant told Saparis that his name was Kevin Stevens, that an attorney named Vernon Evans needed the copies right away for an expungement that was going to happen pretty soon, and that he, appellant, could be reached at Evans' office. Saparis also testified about a book and page collection in which the clerk's office maintains copies of every document accessible to the public. When Saparis looked in the book and page compendium, the orders from the two cases were mysteriously missing. Saparis later met with appellant's probation officer, who provided her with a photograph of appellant and the original that they received in the office from our office of the court orders that were provided in those cases. Saparis testified that, after viewing the photograph provided by Hawkins, she realized that appellant was the person who claimed to be Kevin Stevens. Saparis also inspected the judgment lien books and observed that there were several pages torn out, including a page containing a judgment written against appellant. Circuit Court Assistant Beth Davis testified that she was typing an order relating to Probation Officer Hawkins' letter to the trial judge, advising him of appellant's non-payment of restitution. Davis had attached Hawkins' letter to the two files numbered 93-321 and 93-322 and placed the files on the floor. When appellant entered the clerk's office looking for the files, Davis provided them to Saparis. When appellant returned the files, the probation officer's letter was gone. Davis testified about what occurred after appellant returned the files. Just at that time when I was looking for the probation officer's letter, the first thing that I did was just open the top file to see if maybe it had been slid inside the file, and that is when I realized at the time that the only contents of that file were all copies. There were no original signatures of anything that was there. Davis telephoned Probation Officer Hawkins and requested a copy of the missing letter to the judge to attach to the order. Carol Hawkins testified that she was appellant's probation officer for his March 1993 conviction, for which he received a 12-month, all-suspended sentence and 2 years of probation with some special conditions. After the clerk's office contacted her, Hawkins delivered her entire file relating to appellant to the clerk's office. Assistant Commonwealth's Attorney Norman testified that she represented the state in appellant's June 16, 1995 expungement proceeding. At that proceeding, Norman disagreed with appellant's contention that the charge was nolle prosequit. During the testimony of Saparis, the trial court admitted Commonwealth's Exhibit 1. The jury found appellant guilty of both charges. That's the end of the part of the Virginia opinion that really matters. If everything I just read sounds like total chaos or you're confused, that is okay. Because what I just read, even the condensed version leaving out fights about specific parts of the Virginia State Code, is insanity. Here's what it all really boils down to. Johnson, who had been convicted of crimes in 2 cases, pretended to be a law firm employee and more or less waltzed into the court clerk's office, where he convinced the court staff to hand him the originals from his file, which he allegedly destroyed, or probably just grabbed, replaced with photocopied forgeries claiming that his charges had been dismissed by the government, and handed back. The clerks noticed that the file was thinner than usual and oddly full of copies, but they were apparently too distracted to do anything about it. Then, at a court hearing, knowing that his file contained a forged court order, he lied to a judge, claiming at the hearing that the criminal charges in one of his cases had been dropped. They hadn't. This caught the prosecutors off guard, and chaos ensued as the court realized that its records had been tampered with, that originals were missing, and that all that was left were copies which were difficult to authenticate, if not impossible given the requirements of Virginia law. You had to admire Johnson's sheer chutzpah, but you also had to marvel at his stupidity, because he got caught, and then he was sent to prison. This series of events explain the arrest in 1993 and other cases in Virginia State Court in 1996. But then Johnson was also federally prosecuted in 1996 for the crimes of false statements to a financial institution, bank fraud, and wire fraud. He was convicted, and at some point he was transferred from state prison to federal prison. When you're being prosecuted for state and federal crimes at the same time, that can happen. And then, in 2001, he was convicted of new crimes and sent to federal prison again. This time it was for mail fraud and felony violations of 18 U.S.C. Section 1623, which, if you're not familiar, is a section of the Criminal Code, Title 18, entitled False Declarations Before Grand Jury or Court. Given his history, I guess this isn't all too surprising. The case details are unknown until someone pays to have the papers dug out of the National Archives. We get all the way to June 27, 2019, before Joe Johnson was once again convicted of a crime. Two crimes, actually. Making false statements to a federal official, in this case an FBI agent, and aggravated identity theft. That's because Johnson assumed the identity of a lawyer who is representing an alleged victim of sexual assault who is suing the famous, and then infamous, comedian Bill Cosby. Under a fake name, Johnson threatened the lawyer using a Yahoo email account, and then filed a fake document in federal court under her name that attempted to suggest that her client, the Cosby accuser, was a tax cheat. When the FBI investigated, Johnson lied to them, claiming it wasn't him. It was him. He went to prison again. And then, just like Bill Cosby, he got out when the United States Court of Appeals for the Third Circuit ruled that his impersonation of an attorney and lying to the FBI was not, quote, material to the judgment in the Cosby case. We'll come back to that, because what happened soon after Johnson was released from prison in 2021? Well, in mid-2022, he sued Think. This was my adversary, a man who wasn't just a plain vanilla criminal who wanted his case off the internet, but a man who appeared to be a professional shapeshifter. A man who, over time, chose to use an extremely common name, and he was not just a document forger, but a forger willing to impersonate a judge, a true identity thief, even willing to lie to a clerk about his identity face to face, and willing to impersonate a lawyer and then lie about it to federal agents. And after all of that, a man who got himself out of prison by representing himself and convincing an appellate court that he knew the law better than a federal judge and jury, after which he sued his prosecutor and the FBI agent he had lied to. His willingness to take risk astounded me, but what astounded me even more was how successful he was, because even though he almost never won a case, dozens of them appeared to have settled, and almost every lawyer I talked to was terrified of getting involved. As I had written to the clerks of court in Prince George's County, I had found about 100 lawsuits that Johnson appeared to be a party to in one way or another, and he was still filing away. The court seemed to have no problem with it. How could this be? I started digging. I asked to see copies of appellate cases involving Johnson, but I couldn't get them quickly. While some were available at the Thurgood Marshall Law Library, others had been warehoused. Delayed responses to my requests for help came trickling back from law firms that had refused. Ballard Spahr, Conti Fenn, and Zuckerman Spader in Baltimore, Jassy Vic Carolyn in San Francisco. The clerk of the district court, Robert Prender, also responded to my warning about Johnson being a vexatious litigant, pointing his finger at the circuit court. Even though Johnson almost always started his bogus lawsuits in the district court and then transferred them, the district court wasn't where most of the litigation actually happened. Sounded like a circuit court problem. When I sent the email thread to Paul, my attorney, he responded by criticizing me for having sent anything at all, writing, "The clerk has no role in this other than implementing a judge's order." But that was only partially true. The clerk's role was to stop the vexatious litigant from filing once a judge's order was in place, and, importantly, to notify the judges if they witnessed any abuse of the court so that an order could be in place. I wrote back to Paul telling him, "I think it's fair to say that it's a shared responsibility. Courts prevent all kinds of filings from getting through for all kinds of reasons, ordered or not." He did pass on my messages and CC the administrative judge, Lisa Hall Johnson, in any event. Paul wrote back, again castigating me. "Such an order is an injunction, whose violation is punishable by contempt. Only judges issue injunctions. Sometimes knowing a little bit of law leads you astray." I looked at his email, stunned. Sadly, I wasn't a stranger to this dynamic. I was used to hearing lawyers belittle and abuse pro se litigants. And I was unfortunately used to fighting with my own lawyers in past cases, a dynamic that had led me to believe, as I jokingly told friends, that you needed a doctor to talk to your doctor and you needed a lawyer to talk to your lawyer. But I was really hoping to avoid that kind of conflict this time around. I replied politely, pointing out that I wasn't allowed to formally ask a judge for such an order as a non-attorney representing a corporation. We moved on. Paul had a ton of questions about the status of the case in Ohio with criminal number 2, about Johnson's history, about the case number on Pacer, about PlainSite subscriber count, Think's revenues, its other activities, about whether Think was actually an LLC as Johnson falsely alleged, and then I got an email from my mom. It was a forward with the subject line, FWD: in the matter of Aaron Jacob Greenspan. The forwarded message was addressed to her from an email address that looked like it was from a government agency in Saudi Arabia. The full from address was Criminal Investigation Unit at mau.sa. The message said, quote, "Please contact me to discuss the ongoing criminal investigation regarding the above-named putative defendant, Aaron Greenspan. As I understand it, a warrant is to issue for www.plainsite.org. Thanks." It was bizarre to be sure, and I had my mother email me the full message headers so I could trace it as best I could. In conjunction with my server logs, it didn't take long. Whoever had typed the email had typed it using Yahoo Mail, and they had clicked on the link to www.plainsite.org. It appeared to be someone in Maryland, someone who seemed like he was probably named Joe Johnson. It was a distraction. The government of Saudi Arabia was obviously not involved in an ongoing criminal investigation of me or of PlainSite. I filed it away, made a mental note to come back to it later, and continued researching the questions Paul kept firing at me to prepare for our response in federal court. Paul wanted a comparison of every claim Johnson had ever filed so he could get a better sense of any patterns in his filings. This required a lot of work, and it required access to those cases, which more often than not I didn't have, because in violation of the First Amendment, the Maryland judiciary kept everything secret. Instead, I had to turn to Pacer, hoping that in the process of old cases being removed to federal court, documents had been scanned in. There was still another month to go before Prince George's County would only start to be on electronic filing. By September 28th, the plan was finally starting to feel like it was coming together. I would need to write and sign an affidavit. The paperwork for Paul and Oliver was signed. I had a draft in my inbox for the amended notice of removal. There was progress. Oliver had some questions about the company for the required corporate disclosures. I answered those, and then, finally, at 6:12 p.m., Oliver emailed to confirm that an amended notice of removal signed by an attorney, a civil cover sheet, a disclosure of corporate interest, and the required exhibits, all the original lawsuit materials, had been filed in the case. With a few days to spare, the countdown clock stopped ticking. I could finally breathe a sigh of relief. The next day, Paul got sick with a 101-degree fever. But he kept on emailing and working. While he often gave me the sense that he thought I was deeply stupid, I was impressed, especially given that he was at least 20 years older than me and probably should have been resting in bed. Then, in court that day, Joe Johnson filed a motion. It was a motion to strike, which asks a court to remove something from the record. In this case, Johnson wanted the notice of removal struck because, he argued, quote, "the individual that filed the removal papers, Aaron Greenspan, is a non-party who is not an attorney." He had the right to protest. But Paul took it one step further. He emailed Oliver and me saying, "He is plainly right that Aaron had no business filing what he did. We will have to acknowledge that the September 23rd filing is not a basis for removal." But he has ignored the substantive basis for the removal, which is that in addition to seeking $25,000 in compensatory damages, Johnson seeks 3 additional categories of monetary relief: special and general damages, punitive damages, and attorney's fees. I wrote back saying, "I think that's a bit harsh," explaining that I owned the entire company, etc. I continued, "I think there was and is a colorable argument to be made that he sued the wrong entity. I made a good faith effort to defend my rights, or at least buy time to defend my rights, against someone who is obviously acting in bad faith, and clearly not for the first time." Paul responded, "Aaron, not harsh, accurate." Yet again, I seemed to be in a situation where I had to not only fight my opponent, but also my lawyer. I bristled at the idea that I had no right to represent my own commercial interests. To me, it sounded like forced speech through an attorney. Forced speech is forbidden by the First Amendment. Paul had to respond to Johnson's motion to strike, and to do that, he had to appear in the case. But since he could only practice law in New York and D.C., Oliver had to sponsor him as a local attorney in Maryland. The process of joining a case as an out-of-state attorney involves filing a motion for admission pro hoc vice, and it's a routine occurrence that happens thousands of times per year. Paul filed his pro hoc vice motion on September 30th. On October 1st, Johnson opposed it, which virtually never happens. But by this point, Johnson's modus operandi was clear: to oppose everything, to fight every point of every motion, and then fight it again by filing a motion for reconsideration when he lost, and then to fight a third time on appeal. I respected that, so long as he had valid arguments, but he almost never did. What he argued here came as a surprise to all of us. Quote, "Significantly, the pro hoc vice admission request is an improper attempt to circumvent bar admission, and that Mr. Levy was suspended from the bar of this court and then resigned to avoid the requirement of periodic fees. See ECF number 13 at page 4. Moreover, there is no certificate of good standing from each state bar in which Mr. Levy is a member. In particular, there is no certificate from the District of Columbia Bar, nor the New York State Bar, although Mr. Levy lists active admission to practice before the District of Columbia Bar and New York State Bar, and it appears that he may have dishonestly failed to disclose in his application for admission pro hoc vice the fact that he was recently suspended by the New York courts effective May 16, 2019, for the same similar reason that this court did so. See Exhibit 1, page 63. Paul thought that this was a hoot, because he hadn't been suspended from the bar of any court. Johnson had clumsily found records of a different Paul Levy, Paul Allen Levy with Allen spelled A-L-L-E-N, not Paul Allen Levy with Allen spelled A-L-A-N. Paul, fired up, filed a reply with Oliver's help on October 3rd. What to do about the motion to strike was another issue. Paul didn't really want to have to fight about my notice of removal, and I didn't either. The case was already in federal court, and an amended notice had already been filed. Typically, that would moot the original, but Johnson was trying to argue that the prickly nature of removal meant that the whole process could not proceed because it hadn't been done perfectly in the first place, which meant, from his vantage point, that the court never had jurisdiction to accept an amendment. The best way around this, Paul reasoned, was to remove the case again. This would mean another case number for the same case involving the same parties. It would also involve another $402 filing fee and a $100 pro hoc vice fee. It would probably confuse the judge, but Johnson wouldn't be able to complain. I agreed. So, on October 6th, the last possible day, the Prince George's County Circuit Court case was removed for the third time to federal court and assigned a second federal case number, 8:22-CV-02573-TDC. Judge Twong was now assigned both cases, and it was obvious that Joe Johnson would drum up bureaucratic chaos wherever he went. By that point, there was at least a light at the end of the tunnel. The court had issued an order on October 4th, scheduling a case management conference, what lawyers call a CMC, for October 20th, 2022 at 11 a.m. Eastern Time. It would be the first time the parties would be able to hash out the issues for real, and it would be an opportunity for Paul to highlight the sheer absurdity of what we were dealing with. I expected it to go pretty smoothly. The papers were in order. Even if Paul often spoke to me in a way that even my father didn't, I had excellent lawyers who understood that this case mattered and weren't motivated by money. I knew what federal court was like. The judge was hardly some sort of politically motivated radical, and Johnson's arguments were, in a word, garbage. Was I ever in for a surprise? Broken is produced by Think Press and PlainSite, which are both brought to you by Think Computer Corporation. With the exception of Bill Cosby's comedy, everything you hear or see on this podcast, the script, the sound design, the mixing, the graphic design, the music, the website, and the Dolly image prompting, that's my doing. Until next time, I'm Aaron Greenspan.